Welcome back to Newsday. Thank you for staying with us. Now, for more on the Justice Kikere Ekun judicial reform agenda, we're being joined by Michael Aondoakaa. That's the former Minister of Justice, for a chat about the agenda of the new Chief Justice of the Federation. That's Justice Kudirat Kikere Ekun, and likely effects on the quick dispensation of justice and restoring confidence in the judiciary. Good afternoon. Thank you so much for joining us on Newsday.
Good afternoon.
Of course, Justice Kikere Ekun has emphasized quick dispensation of justice. Now, given the backlog of cases and systemic delays, what specific measures do you believe are needed to significantly speed up the judicial process?
Thank you very much. I think there's nothing to say much as needed to be done. Since she came into office as the acting Chief Justice of Nigeria, all the courts of the Supreme Court have been sitting. And I'm surprised that all the long court lists, the learned justices of the Supreme Court sit as if they are judges of court of first instance. And that is a remarkable achievement. And because of all the panels have been sitting, panel of 555, at least since she came in, not less than 3 panels have been sitting at one time. And that's a very good thing. I don't want to talk of the lyrics. I'm talking more on the practical aspect of his tenure. And she has been doing a very tremendous work. And again, the rules that are coming out are going to avoid unnecessary delay for rules like filing your briefs out of time. Once you are out of time, so automatically you are giving 7 days to file out of time. After that, you are given 1 more opportunity to seek for leave. After that, you don't have any opportunity. These were some of the things that were causing delay. And all those rules that are coming are going to curtail a lot of unnecessary delays. The delay comes partly on the part of the insufficient judges that were in the Supreme Court, and partly on the part of we, the practitioners. Sometimes we have issues with our client, and we maybe in one way or the other, the clients do not come forward and things are delayed to be filed. But with now, the rules are very clear. 7 days, after that, you have 7 days automatic. Then after that, you can now apply for an extension, but within a reasonable time. And if that is not done, then your appeal lapse. And that is a very good thing. And then judgments are coming expeditiously, timesuously. So she has come with a new energy. And she also has the cooperation. The most important thing in the Supreme Court is the cooperation of your fellow brother judges. It seems to me, from an observer point of view, she's a team worker. She's working with them as a team, and I can see the happiness and the resilience of the learned justices to work hard and clear the backlog.
Right. Thank you so much for that take. Now, one of the major pledges that she made, I believe, as she was being screened by the Senate, was that she made a commitment to restoring the Supreme Court to being a policy court. As opposed to, you've touched on some of those elements, as opposed to being a court that for some reason has been plagued with so many other issues that are outside its primary function. Now, this is, of course, a noble ambition. But, given how well you know the intricacies of the Nigerian justice system, especially when our friends in politics are involved, how realistic do you think this ambition is to restore the Supreme Court to being just a policy court?
Well, the Supreme Court generally is a court of justice and the court of the last hope of the people. And when I saw the screening, it does appear with the commitment and the caliber of the new justices, the last hope. Not just her determination, But the pressure that comes from people of authority on the judges generally have to be respected for her to carry out this. Why did I say this? I am saying this in the wake of the fact that judges are judges, our Lord justices in the temple of justice are human beings. The past experience judges had created a fundamental problem for judges to sit and say, I will do justice. Instances where you wake up, you have delivered judgment in the night, you are sleeping in your room, and you have authorities, law enforcement authorities invading your house at midnight. That is judicial intimidation. That was the main thing that affected the morale of the justices. The issue of corruption played a secondary role because the foundation was crippled. When you have judgments, and once you decide judgment, then a set of people will come and go to your homes without a warrant, or even with a warrant, to invade your home to intimidate. The intimidation is the main problem that came out with the sort of judgments our courts. I'm not talking of Supreme Court. She is the Chief Justice of Nigeria. We're not talking of just, she's not talking of just reforming the Supreme Court, but the quality of judgments comes from the lower court, which she supervised through the NJC, must be of quality. And we, first of all, the freedom for them, make them deliver on that important mission is for the authorities to allow the judiciary, which is the last hope of the common man, to exercise without any fear of intimidation. Because what happened, that instant that happened, any judge, high court, court of appeal, any case involving government will say, if I rule, what happens to my family? This was the beginning of the problems we had. And the extended, because of that intimidation, you know, politicians can easily take advantage of this. And that single out of invading the judges in the night, instead of following the process, because there's a process. If you have credible evidence of corruption against the process, if it comes from the state, it's even quicker. The state will staple the process through a petition to the NJC. After all, it's the state that appoints. So once the NJC finds those information or those petitions credible, the state will ab initio remove the judicial officer. But here, there was nothing like that. You just come back from court, either you are writing your judgment, then somebody invades your house. Then the politicians saw that window and started intimidating the judges. And that resulted to the kind of judgments, perhaps, that came up. Now that this government seems to respect the judiciary, the integrity of the judiciary, and the Chief Justice pledging, we are very optimistic that the judgments that will come out of the Supreme Court and come out of our judges in the lower bench, not, I want to mean in the lower courts, like Court of Appeal and Supreme Court, will be of very high quality. Nigerian judges are one of the best in the world. But that intimidation created a problem, and that problem, politicians took advantage of it. Yes, I'm looking at it. That process, the judiciary got intimidated, and politicians took advantage of that, and then we ended up with the problems we had.
Thank you for that, highlighting that point so robustly like you did. Now, I'd like us to touch on the need for balance. How do you assess the balance between expediting cases and ensuring due process, especially when there might be potential risks of prioritizing speed that could compromise the quality of justice?
Both of them can do. Quality and quick dispensation go together. But it goes together in atmosphere. that is conducive for the judges to operate. When I mean atmosphere, I'm not talking of the office, or I'm talking the atmosphere which I highlighted. If a judge goes to court, and the back of the mind he feels this is a democratic society ruled by law, he has nothing to fear. He has nothing to fear. He has nothing to fear to deliver his judgment, because he feels that once he delivers the judgment, prosperity will judge him, not human beings will go after his life. So the quality of judges, the quality of judgments, and quick dispensation, because cases sometimes are delayed because judges are afraid to go into the cases and move it quickly. Some of them also let me play around once I'm transferred, because the cases appear to be toxic. Because if I decide tomorrow my family will be at risk, my job will be at risk. But if that atmosphere is created, they will decide do such cases quickly, and everybody will be happy. Society will be happy.
Now, still on the conversation about intimidation, or rather a body language that seems somewhat aggressive, some critics have come out to say that the CJN's statements yesterday at her screening, or rather the day before at the screening, concerning consequences for senior lawyers who come out to comment on cases on social media and discuss cases sub judice, will be dealt with in a very serious manner. Now, what's your take on that, and where do we draw the line? Because, of course, we all know that there are cases that that come out into the public space and must be discussed and dissected. So where do we draw the line between seeming to silence the voice of senior lawyers while also ensuring that the public remains well informed about cases that are of public interest?
You see, generally, when cases are pending in court, it is quite inappropriate for anybody, not only seniors. In Nigeria, even people who are not lawyers go to interpret judgments of a court. But it's inappropriate for anybody to go and comment on judgment it is, or give opinions or legal opinions on matters that are pending in court. And again, as senior lawyers, we senior lawyers, there's a forum to criticize or write a critique on judgments. Because social media, we have to be careful. We, the senior lawyers, have to be careful, because what we say may be misinterpreted. And what we say is capable of inciting the society on judgments when we do not see the facts of the case. A senior lawyer will wait and see the judgment, the full judgment. Then you write your own critique of the judgment in a civilized manner. We have journals. In England, you have this Law Society journals, several years that they have their journals. We have the Nigerian Bar Journal. Of course, you can criticize where you feel the judgment should be reversed or looked in subsequent cases. You can do in a civilized way through journals, judicial journals, articles, but not to come out of the court and start blowing to that the judges were wrong. This thing creates, that is another form of intimidation. For instance, I was in court last Friday before Justice Lifu. And what was before Justice Lifu was different on the Federal High Court. If I were not in court, I would have been surprised that Justice Lifu said time has passed, 14 days has passed, you can't remove legislators from rivers. But what was before Justice Lifu was completely different from what was reported. And that was very unfortunate. The people who sought to remove was a political party who is seeking to remove people, and where is, if you look at the section of the Constitution relating to removal of people in the House of Rep, Senate, House Assembly who has cross carpet, it's a process that is different from what that case sought to achieve. But before you know, the whole, people say we are shocked with Justice Lifu, but I was in court and I witnessed the proceeding and I heard the judgment. So these are the things that we have to be very, very careful, especially when we come out of court as lawyers and try to criticize the judgment. First, we could at least tally a little, get a copy of the judgment, see the facts the way they are and the way the judge look at it. Then you cannot do a critique through the law journals. And if the social media wants to pick it, they will pick it and say they read from this law journal than us having press conference. That is, to me, I always feel you are doing double trial. You go before a court, journalists are there, they are free to report what they say. Then you come out at the edge of the court and you are addressing the public and talking things that are prejudicial when the trial is going on. And in the process, he said that, I think he's on the right path. I think it's the right thing to do, to bring discipline. Apart from the judiciary, we need to discipline ourselves as lawyers. We need to discipline ourselves to allow the judiciary also have an atmosphere. I spoke of official intimidation coming from authorities. This is also intimidation coming from us. It's not even limited to senior lawyers. It's also limited to non-lawyers, where we criticize. Right of criticism is there. It's guaranteed. But when the criticism is completely at variance with the facts of the case and completely unfounded, I think that is where she was trying to direct her attention. And I think she was in the right direction. Absolutely. I gave you this case of Justice Lifu of the Federal High Court.
Former Minister of
what
Justice.
Came out in the papers was completely at variance.
This has been a very insightful discussion. We could listen to you all day, but unfortunately we've run out of time. Former Minister of Justice Michael Aondoakaa, thank you so much for joining us here on Newsday. We appreciate your time and insight.